This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to talk about the fact that it simply does not pay to cheat Medicare. And when Medicare errs in turning down end vendor's billing, the vendor must first fulfill all administrative remedies before filing suit. Pain care providers' services to Medicare, of course, are not unlimited. In the people of the state of California, Errs San Diego Comprehensive Pain Management versus Jaysen, Eisengrein, and Sandra, the United States District Court for the Southern District of California on September 17, 2025, found that defendants Jaysen, Eisengrein, and Sandra Love's motion to dismiss plaintiff's San Diego Comprehensive Pain Management Center's complaint simply was unfounded because the plaintiff is a medical provider located in San Diego County that treats Medicare beneficiaries with chronic pain, and this is the third action stemming from a suspension of its Medicare payments. Previously, the United States District Court dismissed plaintiff's suit for lack of subject matter jurisdiction because it did not show that it exhausted administrative remedies or show that the exhaustion requirement should be judicially waived. Although providers cannot appeal a temporary payment suspension, a suspension may culminate in an appealable determination if reimbursement claims are subsequently denied. Before filing suit in court, however, a Medicare beneficiary must proceed through 5 levels of administrative review described in regulations issued by the controlling agency, CMS, as follows. 1. An initial determination by the Medicare administrative contractor. 2. A redetermination by the Medicare administrative contractor. 3. Reconsideration by a qualified independent contractor. 4. A hearing before an administrative law judge. And 5. Review by the Medicare Appeals Council. If the beneficiary is dissatisfied with the Appeals Council's decision, he or she may then seek judicial review. In late 2021, plaintiff and 2 related medical practices sued, among others, HHS and Qlarant Integrity Solutions to remove the suspension and receive payments for their outstanding claims. The court analyzed whether waiving the exhaustion requirement was appropriate and found waiver was not appropriate. The court consequently dismissed plaintiff's actions in SDCPMC 1 and SDCPMC 2 for lack of subject matter jurisdiction. The present action, the third trial, ultimately plaintiff's complaint in this action, the present action, is nearly identical to its complaint in SDCPMC 2. Defendants moved to dismiss pursuant to Rule 12b-1 because the ground is decisive. Defendants mount facial and factual challenges to the subject matter jurisdiction, but as a threshold matter, the court concluded that defendant's motion presents both a facial and factual attack to subject matter jurisdiction and defendants mount a factual attack. The court recognizes that the defendants have raised a factual attack on subject matter jurisdiction. First and foremost, the subject matter jurisdiction analysis conducted in SDCPMC 2 does not change simply because plaintiff now alleges that Medicare has terminated the suspension of payments in effect at the time. Plaintiff may not seek judicial review without first obtaining a final agency decision subject to administrative appeal, and failure to exhaust one's administrative remedies deprives federal courts of subject matter jurisdiction over claims arising under the Medicare Act. plaintiff cannot circumvent this court's prior ruling by characterizing the termination of a payment suspension as a final agency decision. Therefore, the court granted the defendant's Rule 12b(1) motion due to plaintiff's failure to establish subject matter jurisdiction. The court emphasized that even if diversity jurisdiction could be established, the Medicare Act's provisions would still preclude subject matter jurisdiction without a final decision issued by the Secretary. Consequently, the case was dismissed without prejudice. In my opinion, healthcare providers who improperly bill Medicare find CMS refuses to pay their claims for payment for services to Medicare patients. The law allows, indeed requires, that the providers seek administrative remedies before they can sue. The defendants' healthcare providers and the plaintiff healthcare providers attempted 3 times to circumvent the need to fulfill administrative remedies, only to find their attempts failed, and the USDC is dismissing their attempt 3 times by attempting to recycle previous litigation. It just didn't work. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog, and if you do, you'll receive notice of every blog posting, usually 5, sometimes 6 a week, and you'll also gain access to the more than 5,150 blog postings. You can also subscribe to these videos at YouTube and Rumble.com, and if you do, I'd appreciate it if you click on the like button on YouTube and the thumbs up button on Rumble.com. Please tell your friends and colleagues about this blog and these videos so that they too can subscribe. And if you're interested in further detail about insurance, insurance claims, insurance law, and insurance fraud, please consider, for a very small fee, subscribing to my Substack publications. Thank you for your attention.